The defendant, Alexander Rodriguez, stands charged in count one of the indictment with the offense of continuous sexual abuse of a young child alleged to have been committed on or about the 11th day of November 2013 through the 11th day of November 2017 in Bexar County, Texas. The defendant, Alexander Rodriguez, stands charged in count two of the indictment with the offense of indecency with a child by sexual contact alleged to have been committed on or about the 14th day of November 2014 in Bexar County, Texas. The defendant, Alexander Rodriguez, stands charged in count three of the indictment with the offense of indecency with a child by sexual contact alleged to have been committed on or about the 15th day of November 2015.
Hold up 3 felony charges here, covering years of alleged abuse, and those fuzzy dates? That's not a mistake. In cases like this, the law gives room for vague timelines when the events stretch over years, but stay with me, because it's about to get intense.
Bexar County, Texas. To all of these offenses, the defendant has pled not guilty. 1. Our law provides that a person commits the offense of continuous sexual abuse of a young child if during a period that is 30 or more days in duration, the person commits 2 or more acts of sexual abuse, and at the time of the commission of each of the acts of sexual abuse, the actor is 17 years of age or older, and the victim is a child younger than 14 years of age.
Oh, things just got real. Under the law, continuous sexual abuse means 2 or more acts over at least 30 days, with the victim under 14. And yes, even over the close contact counts. This statute is built to capture the full scope of long-term abuse, no wiggle room, no loopholes.
Just one moment. We have a new court reporter. Number 2, an act of sexual abuse means any act that is in violation of penal law prohibiting aggravated sexual assault of a child under Section 22.021 of the Texas Penal Code and indecency with a child under Section 21.11A1 of the Texas Penal Code if the actor committed the offense in a manner other than by touching, including touching through clothing, the breast of a child. 3. Child means a person younger than 17 years of age. 4. Texas Penal Code Section 22.021 provides that a person commits the offense of aggravated sexual assault of a child if the person intentionally or knowingly causes the penetration of the anus of a child by any means or causes the anus of a child to contact the sexual organ of another person, including the actor, and if the victim is a child younger than 15 years of age at the time of the offense. 5. Our law provides that a person commits the offense of indecency with a child by sexual contact if, with a child younger than 17 years of age, the person engages in sexual contact with the child or causes the child to engage in sexual contact. Sexual contact means the following acts if committed with the intent to arouse or gratify the sexual desire of any person. Any touching by a person, including touching through clothing of the breast of a child, or any touching by a person, including touching through the clothing of any part of the genitals of a child, or any touching of any part of the body of a child, including touching through clothing with any part of the genitals of a person. 6. A person acts intentionally or with intent with respect to the nature of his conduct.
Let's stop here and talk about intent. The law cares about more than just what happened, it's about why it happened. If the purpose was to arouse or gratify, even indirect contact can be a crime. That means the jury isn't just weighing the act itself, but the motive behind it, and proving that motive. That's where it gets complicated.
Or to the result of his conduct, when it is his conscious objective or desire to engage in the conduct or cause the result. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. 7. Our law provides that the time of the offense alleged in the indictment must be some date anterior to the presentment of the indictment and not so remote that the prosecution of the offense is barred by limitation. The indictment in this case was filed on June 18, 2024. There's no limitation period for the offenses of continuous sexual abuse of a young child, aggravated sexual assault of a child, and indecency with a child by sexual contact. The phrase on or about means that the state is not required to prove that the alleged offense happened on the exact date alleged. With regards to count 1, even though you are not required to agree unanimously on which specific alleged acts of sexual abuse were committed by the defendant, or the exact date when those alleged acts were committed, if they were, in order to find the defendant guilty of the offense of continuous sexual abuse of a young child as charged in count 1 of the indictment, you must agree unanimously that the defendant, during a period that is 30 days or more in duration, committed 2 or more alleged acts of sexual abuse. With regards to count 2, even though the state is not required to prove that the alleged offense happened on the exact date alleged, the jury must be unanimous, which means all 12 of you must agree about the specific instance that is alleged to have occurred, if any, that constituted the offense of indecency with a child by sexual contact as charged in count 2 of the indictment. With regard to count 3, even though the state is not required to prove that the alleged offense happened on the exact date alleged, the jury must be unanimous, which means all 12 of you must agree about the specific instance that is alleged to have occurred, if any, that constituted the offense of indecency with a child by sexual contact as charged.
This is a big one. The jury has to be unanimous on each count, but here's the catch for count 1. They don't have to agree on the exact acts, only that at least 2 happen over a span of 30 plus days. That detail can be a game changer, especially when memories blur and timelines get messy.
In count 3 of the indictment. 8. Count 1. Now, if you find from the evidence beyond a reasonable doubt that in Bexar County, Texas, the defendant, Alexander Rodriguez, did then and there during a period that was 30 days or more in duration, to wit, from, on, or about the 11th day of November 2023, if there's any evidence of other acts of misconduct committed by the defendant against the complainant, such evidence, if any, is not to be considered by you unless you believe such acts were committed beyond a reasonable doubt. With regards to those other acts, if any, you are instructed that said evidence was admitted only for the purpose of showing the state of mind of the defendant and the child in the previous and subsequent relationship between the defendant and the child, if it does, and for no other purposes. Our law provides the defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded to the defendant, and in the event he elects not to testify, that fact cannot be taken as circumstance against him. In this case, the defendant has elected not to.
Here's a major point: Rodriguez didn't take the stand legally. The jury can't hold that against him, and the judge makes sure they know it. But let's be real, jurors are human. What do you think? In a case this serious, should the defendant have to testify? Drop your thoughts in the comments.
Testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet or computer, the internet, any internet service, or any text or instant messaging service, or any social media platform, internet chat room, blog, or website, to include, but not limited to, Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X, to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or other officers or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statement of law made by counsel, if not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial from a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony. But you are bound to receive the law from the court which is herein given to you and be governed by that law. In order to return a verdict, each juror must agree to that verdict. But jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, the juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors, or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied.
Boom, this is it. The whole case hangs on one phrase, beyond a reasonable doubt. That's the toughest legal standard there is if even one juror isn't convinced. Rodriguez walks free. The prosecution carries the full weight here. So, did they truly prove their case or not?
Beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt, and if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you in these instructions, you will acquit him and say by your verdict not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you are retired to the jury room, no one has any authority to communicate with you except the deputy who has you in charge. Do not attempt to talk to the deputy or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the deputy. Any and all communications relative to the case must be written, prepared by the presiding juror, and submitted to the court through the deputy. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas. All right, ladies and gentlemen, each side will have 20 minutes to present their closing arguments to you. State.
Yeah. Good morning, everyone. I know you what the judge just read to me, but I want to clarify three things. Those are specifically about pending charges at least. I'm actually ending with count 3 and then working with count 4. Okay? Count 3, as the judge read, says, if you find evidence beyond reasonable doubt that honor about the elements of all of these cases, okay? You get elements of the checklist. Okay? You're checking up all your boxes. You have to get okay? It's the same for this. Like the scripts, and one about the complete numbers. The first element in count 3. Okay? That means that we have to prove to you that specifically that it's in places 15 that occurred during the time period that we were between, which is second grade, unshelled first period, and 11 and 12, somewhere around there, like you element 1, specified for that, that's that part. Second element, in Bexar County, Texas, she testified to several witnesses heard verified this took place at the house on Chinook Road here in San Antonio, in Bexar County, Texas. Check that box for elements. Next, the defendant, Alexander Rodriguez, at this element 3, at the beginning of her testimony last week, she wrote the component of background there. The man that did this abuse to her, that box is checked as far as element 3. Next element, did engage in sexual contact with Camila Rodriguez, a child younger than 17 years. She's 17 years old, and she testified to you today. This abuse happened between the countries in second grade, she had first grade. That element is proven, and you check that box. By touching parts of the genitals of Emily Blackman, she testified several times throughout these years of abuse, he will touch her vision. If that element is proven, check that. With the intent to arouse or gratify sexual desire of any person, that may be a little bit more complex than the others, but I promise you that, because there is no reason that anybody should touch a child that way other than to gratify their own sexual desires. That is proven. Check that box. That count has been proven to roll on these. Go to count. Now, if you find from evidence beyond a reasonable doubt that first element on about the courtroom amendment of the 14, exact same way as that was for count 3, check that box. Third time Texas, exactly as you did count 3, check that box. Abandoned, Alexander Rodriguez, that element for the exact same way as it did count 3, check that box. They engage in sexual contact with a child younger than 17 years. With the fourth in, check that box. V1 is by touching the breast and the button. Then she testified several times throughout these years of abuse by the defendant to touch her breast nipple area. That is given to you to check that box. Last note, with the intent to arouse or gratify a sexual desire, again, why anyone should touch a child in that way other than to gratify their own sexual desire. Check that box. That count is given to you as well. Now, what's a little bit more complex is count 1, but it really is. I'm going to go through it with you again right now. Count 1. Now, if you find some evidence beyond reasonable doubt in Bexar County, Texas, the defendant, same way as in counts 2 and 3, check that box, did then and there during a period that was 30 days or more in duration. 2 ways. from on or about the 11th day of November 2013 to the 11th day of November 2017. That's the time frame that the victim testified to you all. From the time she was in second grade until she had her first period. That element is proven to you. Check that box off. When Alexander Rodriguez is 17 years of age, he's an adult, ladies and gentlemen, he's older than 17, you check that box, or older, commit 2 or more acts of sexual abuse. Get back to guys on that one. Against Emily Rodriguez, a child younger than 14 years of age. Testified again. This happened from the time she was in second grade until she had her first period, or before the age of 14. That is proven to you. Check that box. So let's get back to that element for use. Commit 2 or more acts of sexual abuse. You all have 3 ways to decide how those 2 acts are proven. Number 1, Alexander Rodriguez did intentionally or knowingly cause the sexual organ of Alexander Rodriguez to penetrate the anus of Emily Rodriguez, a child who was younger than 14 years of age. This is her testifying to you all. He would use his penis to penetrate her anus. Okay? Number 2, Alexander Rodriguez did intentionally or knowingly cause the sexual organ of Alexander Rodriguez to contact the anus of Emily Rodriguez, a child who was younger than 14 years of age. This is her testifying to you all as well about him touching her anus with his penis. The third one, Alexander Rodriguez did intentionally or knowingly engage in sexual contact with Emily Rodriguez, a child younger than 14 years of age, by causing Emily Rodriguez to touch part of the genitals of Alexander Rodriguez with the intent to arouse and gratify the sexual desire of any person. That is her testimony, that at night, in bed, he would pull down her underwear, take his pants off, grab her hand, put it on his penis, put his hand on top of her hand, and use it to masturbate. Those are the 3 options you have. You all do not have to agree on those 3. You sir could think that he penetrated her anus with his penis and touched her anus with his penis. You sir could think that he touched her anus with his penis and he masturbated himself with her anus. You could think that he touched her anus with his penis and he penetrated her anus and the third one as well. You could think that masturbate both times. You could think that they penetrate these both times. It doesn't matter. So long as you all agree on at least 2 of those, that is proven. All 3 of those have actually been proven. You should find him guilty on counts 1, 2, and 3. This man is supposed to be her father, her greatest protector, but unfortunately he has become the man of her nightmares. I think we'll reserve the rest of this time.
Morning, ladies and gentlemen of the jury. It's been a long 2 weeks. I'll try and be as brief as possible, but we have a lot to get through. This is not a grocery checklist. This is not a task list. This is not a quiz. This is his life. And it's serious. This is the rest of his life. So we should treat it as such. We are going to ask that you find him not guilty on all counts. Can you play? Let's talk about what you did here. The investigation or lack thereof. Deputy Hyman. He never spoke to Emily. Child outcry. September 15th of 2022. He goes to the hall and talks to Clarissa. Who the hell is he? Your child just outcried of sexual abuse for the last 5 years? Why wasn't she home? Where was she? Clarissa didn't disclose the affair to that officer because of rules. The only thing that deputy testified was that a crime may have occurred. That was his only task, to take contact information, address information from my client, so that the police had that information. My clients lived there as long as anyone can even remember. Let's talk about Detective Trevino. If anyone needs to change careers, Detective Trevino. He never went to the home. He never collected not one piece of evidence. Reminder, all the exhibits that you got, 40 plus exhibits, not one from the state. Not one. They never talked to the school counselor. That's huge. This was the first adult she told about what allegedly happened. And mind you, when Emily came back and testified, she said the only reason she said something was because the counselor went to go find her. He never talked to Emily. He testified to that. He never talked to Emily. And you know why that's really important? Because Emily got on that stand and was able to be manipulated and malleable to be able to say, oh yeah, I talked to him. She did. They implanted these memories onto her, or she just straight up lied, just to be agreeable. That's terrible. That is absolutely terrible. He never reviewed the body camera footage. It just wasn't important to him. He's about to send this man to prison for the rest of his life, and he can't be bothered to review a video. He never even reviewed his own interview with police to look for inconsistencies. He never talked to the reporting officer to look for inconsistencies. He never requested CPS records. Guess who did? I did. We did. He never requested therapy notes. Guess who did? We did. He never requested medical records. Guess who did? We did. He never got school records. Guess who did? We did. He never talked to friends, family. He never talked to the teachers or principals. Some of you in here, I think, are teachers. You know which students make up big lies and which ones don't. That's huge. They know the goings on at school. They know if someone's a known liar. They know who's telling the truth and who's lying and who makes stuff up. But you couldn't be bothered to do that. They never talked to neighbors who could have heard something going on, seen something going on. Never talked to the principal. Hey, does Emily have any behavioral issues? Does she have problems with authority? Didn't matter. Doesn't matter. Never spoke to Alex's family. That is huge. These are the people that were living in the same household where these alleged abuse was going on. Why not reach out to them? He never spoke to any other potential suspects, which includes people in the home. You know what I find very interesting? State never asked any of the witnesses, did you touch him? Did you touch Emily? Such a simple question, right? Never asked. They teach you in law school, never ask questions you don't know the answer. There was no eyewitnesses, no DNA, no stain exam, and he testified, yeah, victims sometimes. He never collected Emily's cell phone. When Emily testified, she said, we had a really good relationship. She recognized her dad's cell phone from years ago. That's his cell phone. And yeah, we called each other blah, we called each other shorty. We had a great relationship. I wanted to spend more time with him. That is absurd. That is absolutely absurd. Someone has anally raped you for 5 years. Every single visit. And you want to spend more time. Doesn't make sense. He never collected Clarissa's cell phone. If he had, he would have found thousands and thousands of sexually explicit material from Clarissa sent to Alex during the middle of her marriage. He never looked for custody orders. You saw the petition that was produced. It was there. He just took Clarissa's word for it that there was no case. Let's talk about Clarissa. She asked Emily to keep secrets for her benefit, so that she could continue this affair over the course of 4 to 5 years. She testified she couldn't remember her weekly sexual visits with Alex. You heard from multiple members of the household she'd come by every week for their rendezvous, with or without Alex. However, She also testified she would send sexually explicit photographs to him. However, she could not remember the pearls. That doesn't make any sense. She didn't say, I'm not denying that he has those pearls. I just don't remember. That doesn't make sense. You know that. I know that. Everyone here knows that. She testified they had the affair from 2014 to 2007. She also testified, I asked for money. Your daughter has alleged she was anally penetrated for years. And you don't. I'll take your money. You still owe me. Give me the money. Even after he was arrested, she's still asking for money. She would send Alex updates about how she's doing. Oh, she's doing great in the orchestra. What? She goes to this school now. This is the man who raped your child, and I'm going to give you an update as to how she's doing. She misses you. She's wonderful. She's doing really great at school. That doesn't make any sense. She didn't believe that she was actually raped. It doesn't make sense. She told Alex about the abuse that she was suffering at the hands of Roy, her husband. Not just Emily, but the other kids as well. Thousands of sexual communications between the two. Thousands. And she claims that her mom faked those 2 CPS challenges and requested monthly rape kits for Emily. This was before the outcome. Someone asked for monthly rape kits of Emily. And Clarissa says it was probably my mom. Well, the apple doesn't fall far from the tree. Eric Mock. He denied that Emily ever mentioned camping. It happened on the same day, same time, same place. Nothing about camping. Then when she testified in front of you the first time, she didn't mention camping. Then when we brought her back, oh yeah, it happened when we were camping and there was other family around and there was other campgoers, but he still did those things. It doesn't make any sense. It does not make sense. Eric said that she yelled at the pain of penetration. I don't know what the answer is here. She testified in front of you that there was no penetration. She wasn't sure. How can you convict somebody who doesn't even know if something happened to them? How can you put them in prison if you don't know? He never asked if she was sexually active or knew what a penis looked like. He never asked if she was forced to be in the room telling her story. He says that Emily that Alex tried to kiss her. She never told you guys that. She never told the DA's office that. She never told CPS that. She never told the counselor that. She never told her mom. Emily didn't mention showering afterwards. Imagine a 6-year-old child who's been anally penetrated for years, getting up, taking a shower, and staying in the bathroom for hours. Never mentioned it. Not to him.
Where's he? Where's the school counselor? Where are the people who were supposedly pivotal in this story? The defense is driving home a major point. Key voices are missing. And in trial strategy, absent witnesses can translate to absent credibility.
Roy Herrera. Where is he? He was subpoenaed. Clarissa confirmed he was subpoenaed for us. We wanted to hear from him. We wanted to see what kind of influence he had over Emily. But he was stuck and didn't want to be questioned. School counselor, where is she? She was the first adult that talked. Where is she? The timeline. We know the furling procedure happened in 2011. 2014, Alex moves in with his mother, and the visits start happening. Alex, Christina, and Ethan are living together. She was 7. Then in 2015, Alex and Clarissa begin their affair. Again, Alex, Christina, Ethan are all living together. Then 2016, the affair continues. Alex, Clarissa, Ethan are living together. Emily is 9. 2017. I put down here, Emily gets her period. Who knows? She has no idea whether it's 2017, 2018, 2019. But somewhere in there, she's living with Alex, John Paul, and Ethan. And we know the affair keeps happening because John Paul and Ethan both testified. Clarissa's coming by. 2020, Alex and Clarissa end their relationship, and things spiral. He meets Lisette and starts dating her, and he's still living with Alex, John Paul, and Ethan. This was when Emily's 13. 2021, Clarissa starts asking for money. They're not dating anymore. She wants her money. She's not getting those dates anymore. She wants her money. Lisette moves in with the kids. Emily allegedly tries to commit suicide. Alex, Lisette, and the kids all move in together. And she doesn't want to share her. She doesn't want to be there. She is starting to pull away. 2022, Emily starts sneaking out, and somebody files and asks for monthly rape kits of Emily with CPS. Then 3 months later, here comes the out. Alex, Lisette, and the CPS interviews the kid. No outcries. No outcries of this. And they leave the kids with Alex. Little kids. No one.
Here's the curveball. Even after the alleged abuse surfaces, Emily keeps messaging Alex and Lisette, saying she misses them and sharing life updates. The defense is banking on the sticking in the jury's mind. Does that sound like the behavior of someone who's been abused?
After the outcry, guess who's still messaging Lisette and Alex? Emily. She misses them. She wants to talk to them. She wants to see how they're doing. She gives them updates about herself and her mother. And what I find the strangest about all of this, Clarissa moves to Houston with Roy and the other kids and leaves Emily. Who does that? You have a man who is her father, who has legal custody of her, right? And you move to another city without her, without any protection whatsoever. He hasn't been arrested at that point. How protected is she as a mother? She knew this isn't true. She knows this was not true. Again, Alex, Lisette, and the kids continue to be together. In 2023, in January 2023, the detective turned the case into the district attorney's office.
5 minutes.
Good. Clarissa continues in 2024 to message Lisette and Alex. Alex is arrested. Then, Emily's still going on vacation with his family. None of that makes any sense. None of it. And guess who's still asking for money? Clarissa. We talked about when is it too late to walk a lie back. Emily stated,
A lie travels halfway around the world before the truth can get its shoes on. The defense isn't just being poetic. They're warning jurors that once a full story takes root, the damage is nearly impossible to reverse, even if it's later proven wrong.
I asked, do you think you're going to get in trouble if you say you made all of this up? And she said yes. Winston Churchill said, a lie gets halfway around the world before the truth has a chance to put on his pants. The DA's office sat on this case for a year and a half. That disadvantages us.
Sustain.
Common sense. They have the burden of proof. You can find somebody guilty based on the testimony of one witness, but that one witness has to be credible, and Emily is not credible. Remember the standard of proof. They have to prove every element beyond a reasonable doubt. And remember, to terminate your rights as a parent, it has to be clear and convincing. If it's not enough to terminate your rights as a parent, which obviously it wasn't for his rights were never terminated, then it's not enough evidence to take his for the rest of it.
Here's the play. The defense is stacking timelines side by side, age, year, key events. And every time, Emily's story changes. Was she 5, 6, 7? Did it end at 10 or 12? This isn't random trivia. It's a calculated push to make jurors see uncertainty as doubt.
The inconsistencies. Emily said it's every other weekend in the same room, same time and place, and then years later she said, oh, actually, we were camping. She claimed she felt something wet on her back, and then later claimed she actually smelled it and tasted it. Then she said the abuse started at 5. Oh, maybe 6. Maybe 7. It stopped when I was 10, maybe 11, maybe 12. She claimed she was anally penetrated, then changed her mind and said, no, actually, I don't think it was. I think it was only contact, but no penetration. But we know there was no signs of penetration. We know there was no staining, there were no tears, no blood. No emotional changes at the time of the alleged abuse. Nobody knew anything was happening. She said she was pretending to be asleep, so she had her eyes open and closed. She told CPS she was asked specifically by CPS during this time, is anyone touching me? No. She was asked by her mom, is anyone touching me? No. She told his mother, Alex's mother, she felt guilty, and that she still does to this day. You do not feel guilty about something unless you've done something wrong. She never mentioned age. It's reasonable doubt. There's no physical evidence, there's no eyewitnesses, there's no signs of abuse. Marissa has a motive to lie. She manipulated Emily. Emily's testimony is unreliable. Look at these messages. Is this someone who has been sexually abused? I want to see more of you. You're the best dad in the world. Nobody forced you to do that. Nobody forced you to do that. Read those messages.
This is the defense's warning shot. If one emotionally fragile child's word is enough, then no one is safe from accusation. They're not just fighting for Alex here. They're planning the idea. That jurors could just as easily be in his place.
If at the thought that you had when the state rested your case, is that it? Is that all it takes for you to be charged with a crime? Is the word of an emotionally disturbed child? That is pretty scary. Because any one of you could be in this situation. There's no evidence of this. This defense put on 40 plus exhibits and the state put on 0. Not guilty does not mean you don't believe something happened. Not guilty doesn't mean I think Emily is lying about everything. It doesn't mean that Alex is a state or that he's gonna even get custody. It does mean that the state can prove each and every one of their elements beyond a reasonable doubt. It does mean that you upheld your oath. You swore and you took an oath to follow the law. And if you have doubts, and I know you, then your vote should be not. If you go back to the jury room and you think to yourself,
here's the closer. If you walk into that jury room unsure who's telling the truth, the defense says your duty is clear, not guilty. That's reasonable doubt doing exactly what it's meant to do.
I don't know who's telling the truth or who's lying. I don't know the then it's simple, not guilty. I want you to look at the verdict form in the back. Not guilty is at the top on each count. That's 3 counts. And you as a presiding juror, they sign at the top. And the end is ridiculous trial and nightmare for Alex. Thank you very much.
Statement 13 minutes, 11 seconds.
Thank you, Judge.
I felt guilty. I felt guilty. I wish I had talked to him about it. I felt scared. I thought you were afraid of him. I was. Parts of him. There were good parts of him too. I felt guilty. Like I was ruining his life, like it was my fault. Members of the jury, you never want to hear a child say what Emily said. You don't want to hear it because you know it's true. You know that even after everything her father has done to her, she loves him. Even after all the years of molestation and sexual abuse, she loves him. Even after getting called a liar, she loves him. And I'll bookend that with the testimony of the very last person you heard from the defense, Deanna. Defense asked if Emily was malleable, right? That was the defense's word, malleable. And Deanna said, I'd like to say malleable. And Deanna noted two things after that. She said that Emily was concerned with hurting someone else's feelings, and she said that Emily will feel really bad if she thinks she's hurt your feelings. Did you hear that in the trial? You bet you did. Repeatedly. I felt guilty. It was my fault. And she couldn't even raise her voice on the stand. The same kid that would go to an HEB, remember the testimony of Ethan, and stand zoned out, milk, right? That's the same kid you saw on the stand. In fact, in line with not raising her voice, this is a kid that didn't feel like she had a voice. She didn't have a voice, so she tried to kill herself. And notice during the defense's cross-examination, there was a lot of discussion, right, on the exact day that she attempted suicide, right? The exact day. Was it the same day that you talked to the counselor? No, not the same day. You told child safe it was the same day. No, I don't remember saying that. Not the same day. I never told someone it was the same day. I didn't try to kill myself that day. Members of the jury, that's the when. The when, right? So in the who, what, when, where, why analysis, we all agree on the who, the what, the where, the why. We really almost agree to the exact day on the when. You know what that tells you with respect to the attempted suicide? That it happened. But go with me here. With respect to the attempted suicide, the whole time she's talking about that, I think the parallels became very clear in twofold. One, the lack of specificity with the date as it relates to both her attempted suicide and her first period. Okay? This is a girl that struggles with the exactitude of dates. This is not a girl that struggles with the clarity of the memorability of those events. You know what is clear? She attempted suicide. You know what else is?
The prosecutor is doubling down on the clarity card, arguing that while dates may blur, two facts stand firm: Emily's suicide attempt and the abuse ending after her first period. It's a deliberate connection designed to lock cause and effect in the jury's mind.
Clear that when she got her first period, her father stopped sexually abusing her. Those were clear. And the second parallel between those two events, right, is that the defense had to again attack the minutiae or specificity in order to detract from the truth. Right? Defense. So it was every weekend? No, almost. So it was all the time? No, almost. Emily said he would say my name or talk to me. He would check to see if I was awake. You never told anyone he would assault you during the alleged assault. No, not during. Beforehand, sometimes afterward, to see if I was awake. And I'm not splitting hairs. I am not splitting hairs. Almost every weekend is not every week. Talking to your daughter before or after is not talking to her literally while you're in the act of assaulting her. They're two different things. She was clear on that from start to finish.
This is a strategic callback. Remember that quirky coffee analogy from jury selection? The prosecutor's cashing in now, painting the defense's whole approach as a distraction tactic. In trial work, callbacks stick. They make jurors feel in on the story.
Now we're going to dive into the defense counsel arguments here, but first, remember in voir dire when I discussed the rules of football? You remember that? I did that because I knew I'd be spending the majority of my time in this trial objecting. I know how they argue. You saw that. Remember during voir dire 2 when I was talking about the Sabrina Carpenter, the coffee example, the jury number 52? I knew they would spend the majority of their time in this trial trying to muddy the waters, even with the non-victim witnesses. Right? So remember Eric Mata? Remember the forensic interviewer? He got on the stand. What about the camping trips? What about the mother? What about the affair? I don't know. We never discussed that. I don't recall. You don't know? You never discussed that? You don't recall? Finally, Eric, a grown man, you watched it. He put his hands up and said, I'm sorry, I'm not trying to be disrespectful. I don't know what you're talking about. That's what he said. Does that remind you of anything? It's coffee. It's coffee. It's coffee. It's almost like I knew what they were going to do. That's how they argue. Now, some of these defense counsel arguments, you just heard counsel talk about the fact that Emily didn't tell her mother everything. They just said that. She doesn't know the full extent. She's learning the full extent right here, right now. With respect to Eric Mata, he was able to testify as to the things he heard because the victim specified with clarity the things that happened. That's why I was able to ask him on the stand, what did she say? What did she tell you? Right? The law provides that opportunity for him specifically because he can testify as to the specificity that she relayed. I didn't have that opportunity with other witnesses. I had it with him. That's the opportunity the law provides. So, counsel talks about the 42 exhibits or whatever number. Yeah, look at those pictures of SeaWorld. Okay, look at the pictures of the theme park. What do you expect this kid to do for 4 years? Hide under a blanket? Is that what you want? What do you expect? We talked about in Board Dyer how kids react differently. We talked about it for that exact reason. It's always the photo of SeaWorld.
Here's the emotional flip. Those theme park photos and Father's Day cards. The prosecutor says they don't disprove abuse. In fact, she argues, love and abuse can tragically live side by side. When the abuser is a parent, that's a gut punch aimed straight at the jury's emotions.
Oh, and she would text him and write him Father's Day cards. Again, what did you expect? That's why we didn't even object to those coming in. The photos themselves are a disgusting enough notion. We talked about that, right? I went through it. Daylight, people there. I did all that. Cross-examination. We already talked about that. But the letters, does that not make perfect sense for a kid that loves her father? A kid that doesn't want to hurt anyone's feelings? In fact, this is actually somebody... She has no problem hurting herself, right? But it's others that she cares about. What was she supposed to do? So if she's a good student, nobody ever noticed any issues, but she must be lying about sexual assault. She had bad grades? Well, you had bad grades. You were mad at your father about something, so you made up sexual assault. And either way, that's how they're going to paint it. Other people lived in the home with paper-thin walls. It's always the paper-thin walls, right? So thin you could hear someone put their socks on. I asked that ridiculous question. He backed off on it. But that's my first question was, so thin you could hear someone put their socks on? I mean, yeah. So someone that said they went live for the family, but you could hear socks being put on in another room? Okay, that's incredible. That's incredible testimony.
She's tearing apart the no DNA argument, reminding the jury that years passed before Emily spoke up in child abuse cases. That delay often means there's nothing physical left to test. It's a textbook prosecution counter, and it hits hard.
Another defensive argument was the lack of DNA or physical evidence. This was a years-long delayed outcry. Years! Right? This is what we've talked about. Or not. This is why Detective Trevino said repeatedly, you're not going to get evidence after 120 hours. This wasn't 120 hour delayed outcry. It wasn't 120 days. Right? It wasn't 120 weeks. This was years and years and years. And so finally, she told the person that she thought couldn't say anything. Remember when she testified? She liked the counselor because she was under the impression that that person couldn't say anything. Does that sound consistent? Like someone who doesn't want to hurt someone's feelings? The girl that somehow still loves her father, that raped and molested her, the girl that doesn't have a motive to lie. Let's get into motive. She didn't have a motive back then, right? There's no nasty divorce with $1 million home, right? There's no real custody issues at all. Plenty of testimony after the period, he took her there. That's all contextual. There's no haranguing. There's no mistake. No problems, no divorce, no custody issues. Things just kind of seem to be a handshake agreement. Really no problems. Now, the defense can posture that Emily was receiving pressure from her mother. Deanna Wood, their own witness, said again that her impression of Emily was that she was not malleable. She went on to say that she herself did not see any pressure or power from mother over Emily. That's their witness. Eric Monta noted that she didn't appear to be under any external pressure or influence. And then he provided the additional context. They child safe, they screen for coaching too. That's what forensics do. That's what he's done for over 2,500 forensic interviews. This is what he does.
Here's the prosecutor's anchor. If Emily were lying, she could have kept it simple. It happened every time, but she didn't. Instead, her story stayed messy and imperfect. End of the state. That's exactly what makes it ring true.
If she had a motive to lie, then just say his penis went inside you. You're almost all the way there. You yelped and felt pain. I'm telling you, if you have a motive to lie, just go all the way. Why stop there? Why? And if you really have a motive to lie, just say it when it happened every single time you went over there. My God, wouldn't that be easier? Not almost, not correctly, almost every time. Every time, almost. If you're really gonna lie, God, just make it simple. Make it a binary. Every time I went over there, I was raped. Every time? Yeah, every time. Yep, every time. Simple, every time. If you have a motive to lie, that's what you do. And if you have a motive to lie, just say you were facing him. Don't speak to the truth of the fact that he would whisper behind you. He's the one that never went into the room. You knew it was him. Just lie and say, yep, look right in his eyes every single time you molested me. If you have a motive to lie, just do it. Just take it all the way. Why are you stopping there? She doesn't have a motive to lie. There is no motive to lie. The mom's pressure over her, for what? To what end? What are we doing here? There is no motive to lie. She didn't back then. She doesn't now. She did it not once. And I got her words on her words myself. Right? Remember when they called her back up again, I drew the timeline on the board right here. Right, I put the X, second grade, to the time that the period happened. And I wasn't sitting in between the tables, right? Remember the first time I sat between the table, and asking her question, what happened? Tell me about this. I stood literally while I'm sitting there, I put a marker in her face, and I say, don't just tell me what I want to hear. Second grade? Was it first grade? Was it third grade? It was second. Okay, well, did it happen when the abuse stop when your period happened? Were you 10, 11, 12? Don't just tell me what I want to hear. I've never spoken to a child witness like that. Don't just tell me what you think I want to hear. I almost yelled at them. You guys, I was standing right there. But I had to do that. I had to yell at her. I had to put the marker in her face. I had to draw the line. I had to say all those things because when you go back there, I want you to know that she's the same quiet girl. She's consistent, even when it's me that's yelling at her. And if she was the same girl without a motive to lie. We have the sensory details about wet and hairy. Eric Mata told you about the importance of those details. But then you go to the consistency and corroboration across the accounts. I kind of drew that grid yesterday, right? You have what she told CPS. You have what she told the forensic interview. You have what she told the DA's office. We have the testimony where Detective Trevino, like, he's the 30,000 foot guy, sees everything. Clarity and consistency across all the accounts. There's actually some testimony about the therapist. It was very good. His discussion with the detective. She said she was consistent in her outcry even with the therapist years later. She got on the stand Thursday. She got on the stand yesterday. So that's 7 different accounts across multiple years, across multiple people, and it's the same story every single time. It's the same account. It's the same retelling. It's the same details. It's the same person. With respect to count 1, continuous sexual abuse of a young child, you're going to see it right here, like Rick pointed out to you. You're going to see count 2, indecency with a child by contact. And you're going to see count 3, indecency with a child by contact. Given everything we've talked about, the true motive to lie, the fact that she was clear and consistent across those 7 accounts, across all those temporal dimensions, across all those time periods, across all those people, we're going to respectfully request a verdict. Thank you.
All right, ladies and gentlemen, you've heard all the evidence in this case, and Deputy Laura will take you to the back. All right, so to people in the gallery, we've been informed we have a verdict. So this is what I'm going to tell everyone. And I want everybody to hear me clearly. There will not be any outbursts. There will not be any cheers. There will not be any tears. We're not going to have that. Because that puts the deputies on high alert. And then you know what's going to end up happening? Whatever side you're on with the cheers or whatever it may be, a deputy is going to tap you on your shoulder and you will not be coming back to this courtroom unless you're called as a witness. And there's not going to be any explanation needed because that's how it's going to be. So let the deputies have an easy job today. All right, this one's been taken care of. This is supposed to come back on the 24th. And I think... All right, the defendant is present in the courtroom. Are both parties ready to receive the verdict? All right, let's bring the jurors in.
All right, to the jury.
All right, everyone, please be seated. All right, ladies and gentlemen, it's the court's understanding that you've reached a verdict in this case. Is that correct? And is the verdict unanimous? All right, if you'll hand the verdict form to the deputy, please. Thank you, Deputy Laura.
Here, the defense zeroes in on the heart of the case, credibility, their point. If the alleged victim can't even say for sure whether penetration occurred, how can you send someone to prison? This isn't just sowing doubt. It's suggesting the entire accusation might be on shaky ground. Legal note, in many jurisdictions, a single witness's testimony can be enough for conviction, but only if it's credible. Beyond a reasonable doubt, the defense's arguing Emily's uncertainty doesn't clear that bar.
All right. With regards to count one, it states, we, the jury, find the defendant guilty of the offense of continuous sexual abuse of a young child. Count two, we, the jury, find the defendant guilty of the offense of indecency with a child. And count three, we, the jury, find the defendant guilty of the offense of indecency with a child. Does anyone wish to have the jury poll? All right, ladies and gentlemen, I'm going to ask you if this is your true verdict. If this is your verdict, I need you to answer yes. Does everyone understand? All right, so we'll start on the front row. Is this your verdict?
Yeah.
Is this your verdict? 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 All right. Thank you. So you have done your service in this trial. So I'm going to have you, Deputy Laura, take you all to the back, and I'll come back and speak with you briefly, okay? Everyone, please rise for the jurors. All right, everyone, please be seated. All right, so legally, I don't need to do a PSI. We can have a hearing now for sentencing if both parties are ready to proceed with sentencing. All right, I'll let you speak to your client. I'm going to speak with the jury, and I'll be right back.